नाउ दे से कि सुमित्रा कुमारी जो है मोहन केवट की बेटी है और मोहन केवट ऑलरेडी पार्टी है, तो हमको सुमित्रा कुमारी को हम गलती से पार्टी बना दिया। नाउ योर लॉर्डशिप में काइंडली सी टाइटल अपील जिससे अराइज कर रहा है सेकंड अपील।
ये फिर उसके अलावा क्या ये आगे फाइल करो?
बट ये आप फाइल कर दिए कि सुमित्रा कुमारी को ऐड कर दीजिए पार्टी।
ऐड
शांति, हाँ एक वन टाइम का
पहले ठीक से देख ले।
हाँ।
हम लोग कहीं ये नहीं बोले हैं कि हम लोग गलती से बना दिए हैं, और ऐड बोल रहे हैं शांति 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 who is
कुछ
the-
नहीं ऐड हो सकता, प्लीज डोंट टेल अस ऑल दिस।
If that is not required, I submitted by way of amendment precaution. By way of amendment precaution,
You
since
see,
they come.
the identity which you have disclosed by way of rejoinder is of a different person altogether.
Now they
We
have
will not take that as
only
the
one thing, only for purpose of submission. They were given time because of this reason. By therefore I refer to order number 26. They were given time to respond. They have not made any objection in writing to any of this.
Need not be.
Now therefore that order 26 records they were given time to respond.
Maybe they have not responded, but we see it on the face of it.
Yes. Therefore, if at all we have made a prayer, we have filed a reply to that, and we have made a prayer to delete the name of Sumitra Devi, because Sumitra Devi, one Sumitra Devi was there, who was daughter of Mohan Kevat, who died in minority, living without any there was no legal heirs, legal representatives, and therefore we have made a prayer for deleting name of Sumitra Devi. If that is considered, and then in that event we will not press that idea because we filed it. Since there is no objection, so we filed it
We will say it is abated. We will not say deleted.
because so far as
You see, when the identity, you are disputing the identity itself.
because then it is to be shown, then it is to be shown by them since they are raising it. They
What
are raising
so?
that objection.
You are raising that objection.
No, they have raised that objection. That it has abated. It has come up since they have raised the objection.
Even if they do not raise the objection.
Now,
If a person is dead and it is mentioned on record, the proceeding abates.
then they have to show.
They don't need to
No,
show
only one thing
anything.
which I am submitting. It is up to this honorable court to consider. I am only submitting that then they have to show that Sumitra Devi was actually daughter of Ram Prasad Kevat and she died.
There is the dispute on that.
But they are
Is there any dispute in the record that Sumitra Devi named person was not the daughter of Ram Prasad Kevat?
We have filed a reply to their idea.
Not here. You see, if in the trial court you have not disputed that Sumitra Devi was the son of Ram Prasad Kevat, how will you dispute it in second appeal?
As soon as it has been filed and objection raised, then we have said that actual status.
No,
we have,
what actual
we
status?
have brought on record the actual status.
Lord, we see
and now they have not
degree.
filed. Just
अपने
let
को
me
degree
just
जो
let me
party
allow.
mention
Just
है,
one.
उसको देखते हैं।
Now they have not
उससे
filed
क्या?
any response in writing.
Need not. You will not be permitted to change the identity of any of the respondent by changing their father's name. Because that was never an objection raised before at any stage.
And we have not made a prayer, specific prayer for changing the father's name. We have made a prayer that since Sumitra Devi, who was there, she is dead, giving no legal representative. So we have made a prayer
No,
for
that
deleting her
is
name.
not the
That is
prayer. You just have a look at your interlocutory application. You just look at your interlocutory application. Due to inadvertence, one Sumitra Kumari is impeached as respondent in the second appeal as a daughter of Ram Prasad Kevat.
Now only this statement your lordship will tally with the decree जिससे
No,
अपील अराइज है, और उसमें पार्टी पोजीशन है।
We will not permit anybody to change the party position.
Exactly. उसमें पार्टी पोजीशन मेंशन है लॉर्ड इम्प्यून जजमेंट में और उसके डिक्री में।
You are just disputing the entire genealogy of Ram Prasad Kevat. चलो लिखिए सेकेंड अपील नंबर 26 of 1998 in bracket R. IA number 8809 of 24 has been filed seeking deletion of respondent number 8. Sumitra Kumari, minor daughter of late Ram Prasad Mehto, राम प्रसाद मेहतो लिखा हुआ है, करेक्शन करिए.
In title suit plots judgment, she was respondent number 5B.
Ram Prasad Mehta, yes. By stating that due to inadvertence, one Sumitra Kumari has been included as respondent in the second appeal as daughter of Ram Prasad Khewat. And that Ram Prasad Khewat had two daughters, namely Shanti Kumar and Munni Kumari, besides his wife, namely Mausama Panwa Devi, and son, namely Sunil Khewat. It has been stated that Sumitra Kumari was the daughter of Mohan Khewat, who is already on record as respondent number 11. And therefore, a prayer has been made only for deletion of the name of respondent number 8. As respondent number 11, namely Mohan Khewat, is already on record. Correct? यही है आपका? The learned counsel for the respondents.
And we have made further pleadings about the family details in that act.
You have already mentioned that. The learned counsel for the respondents has opposed the prayer and has submitted that through this interlocutory application, the very identity of respondent number 8 is sought to be changed by changing the name of her father and showing that she was son of respondent number 11.
Daughter. Sumitra.
She was the daughter of respondent number 11. The learned counsel submits that the case, decreed that there was no dispute regarding identity of Sumitra Devi as daughter of Ram Prasad Mehta. And the identity cannot be changed. The learned counsel has submitted that the proceeding as against respondent number 8 has already abated.
And she was not the party since very beginning. In title suit degree, she was 5B. And in title appeal
And
judgment.
she was party since very beginning.
Yes.
In title suit, she was 5B.
And in title appeal.
In title appeal,
She was respondent
she
number
was
8.
respondent number 8.
Which is evident from the title suit degree and the judgment.
Yes.
Yes.
The learned counsel has submitted that the prayer for deletion of respondent number 8 may not be allowed. After hearing the learned counsel for the parties and going to the interlocutory application seeking deletion of respondent number 8 by stating that her father Mohan Khewat, respondent number 11, is already on record. This court is of the view that the identity of respondent number 8 cannot be changed, and admittedly she has been in the record right from beginning. The simpliciter prayer for deletion is not maintainable, rather the proceeding is abated as against respondent number 8. Accordingly, IE number 8809 is disposed of by observing that the name of respondent number 8 would be deleted from the cause title, but the deletion will be on account of abatement. It is observed from the decree passed by the learned First Appellate Court that Sumitra Kumari and Munni Kumari both were daughters of late Ram Prasad Mehta. And Munni Kumari is now respondent number 9 in this appeal. Correct?
Yes.
हो गया आपका IA भी closed? You filed IA number?
But my IA number 8023.
8023 or 24 is also closed. बताइए आप क्या बचा?
Yes, merits.
चलिए आगे.
The questions of
Lord,
which
once
are
the lordship has had given, so far as respondent number 8 is concerned,
It has abated.
it has abated. So once, then your lordship will not close my IA, your lordship will pass an order on my IA.
No.
Because what? Once it is abated, against one
The
of
consequence of abatement
yes.
in connection with
Will be
respondent
left.
number 8 will be considered at the time of final disposal of this case. Right? The parties have commenced their arguments chaliye, on the merits. शुरू करिए.
so far as the
पहले abatement का कहानी शुरू करिए.
हाँ जी, so far as abatement is concerned, it is relevant for the purpose of deciding as to whether the appeal would abate as a whole or it could be the replaceable. The most relevant fact would be that the respondent number 8, this is respondent number 8, she was the defendant. It is the appeal is filed by the defendant.
Who was the original defendant? Her father or herself?
Her father.
नाम बताइए.
Her father.
नाम
As per
बताइए.
record, Ram Prasad Kewat. Her father was one
राम
of
प्रसाद महतो दिख रहा है. आप राम प्रसाद केवट कहाँ से बोल?
वो हाँ चेंज हुआ राम प्रसाद केवट और महतो फिर वहाँ पर डिग्री में चेंज हुआ है.
डिग्री में कैसे ऐसे चेंज हो जाए?
हाँ मतलब वहाँ परमिशन मिला होगा उसमें जो डिग्री हुआ डिग्री में वही लिखा होगा माइनर डॉटर ऑफ लेट राम प्रसाद महतो जो अपीलेट डिग्री में है.
क्या नाम इनका? सावित्री ना?
सुमित्रा.
She was the original defendant. Number 5 was Ram Prasad Kevat,
Yes.
right? Original defendant number 5.
Yes.
Okay. He was substituted by 3 persons.
Yes.
One minor son and 2 minor daughters.
Yes.
And wife 4.
Mosammat Palwa Devi,
हाँ.
wife.
He was substituted by 5 to 5C. Substitution, right?
Palwa, Sunil, Sumitra, and Muni.
Wife, son, 2 minor daughters. Son was also minor. Wife is on record or she has expired? Wife का नाम है
वाइफ का नाम है
पनवा देवी. Wife is Panva Devi.
Yes.
She is there on record or she has expired?
She's there on record in the
Panva Devi. respondent number 6, she is there on record.
Yes. Now on the issue of abatement, since the suit was of the respondents were the original plaintiffs, they sought for a decree to the test of severability of the decree, because in the event
Respondents were the plaintiffs.
the respondents were the plaintiffs, the original plaintiff, the contesting respondent.
How do you say respondents were the plaintiffs?
Yes, respondent number 1 and 2.
No, title suit respondent.
Yes.
Plaintiff was one Ratan Lal Jain.
Yes, and the contesting respondents, whom learned friend is representing, they are the respondents.
So you cannot say that the respondents were the plaintiffs.
They
They might be pro forma. We do not know what was their status.
Now the issue is that the issue of abatement arises. Issue of abatement arises to avoid any legal implication that whether the decree is severable or not. Now in the event, the appeal fails. The appeal fails. The decree as reversed by the learned appellate court will stand. In that event, they will certainly be entitled for that decree. There is no doubt. In the event, otherwise, in the event we succeed in the appeal, then there suit or the as modified in the appeal that goes. In the event the appeal allows. So there also there will be no question of severability of decree in both eventually, because since the situation had been different,
The suit was decreed or dismissed?
the suit was decreed. What happened? The issues were like this. The suit was decreed by holding their
First appeal allowed.
first appeal allowed with certain modification. The suit was decreed by holding that their title document which they were claiming, a Sada salary, to be valid, and by denying the relief of adverse possession. And we moved in appeal. In appeal, their title document was not considered to be illegal. The appellate court reversed to that extent that the title document is not legal, it is not valid, since it contravenes section 46 of the Chotapur Tenancy Act, and on that score, the suit judgment was modified, but the findings were kept as it is for the reason that the learned appellate court came to a finding that they have perfected their title by adverse possession. Now the learned appellate court's judgment, which would form part of the decree as of now, is on basis of prescription by adverse possession, only on that basis. And therefore the questions of law have been accordingly.
Whose adverse possession has been declared?
There, the original plaintiffs.
That is only one plaintiff.
Yes, only one. Subsequently, they died and their legal heirs as per the original plaintiff.
Who are the legal heirs of original plaintiff?
Ratan Lal Jain,
Yes.
he was the original plaintiff.
Yes.
Ratan Lal Jain, and
There
then
is only one plaintiff. How is Ratan Lal Jain related to this respondent number 8?
they are not related.
They-
They are not related.
Why are they party? They are only pro forma parties.
They are pro forma party because they were all co-defendant along with the present appealants.
Why they were made co-defendants? Is there any right of their involved in the case?
Since they were parties, they are of all the same family, same general.
Respondent number 6 belongs to the family of Ratan Lal Jain.
No, not
They-
Ratan Lal. They were all co-defendants. They were all co-defendants.
Co-defendant is another thing. You said that first you said that respondent number 6 was the plaintiff.
No,
No, that is not there. Then you
Respondent,
said that respondent number 8 was the pro forma defendant. So I just want to know, if they are
Yes.
pro forma defendant, why have been they made party?
if this honorable court kindly takes the plaint for a moment, the record is there, the plaint for a moment, that will
Plaintiff.
all the defendants.
So how the decree is severable?
Because so far as the suit is concerned, the suit was not filed by the deceased defendant. The suit was not filed. She did not sought for a decree. And in the event the appeal succeeds, meaning thereby the suit fails. So then there would be no question of any enforcement of any decree or something. So there would be no question of severability. in that event. If the appeal succeeds, and even if the appeal fails, then also appeal fails, the decree will be there of the original plaintiff or his surviving legal representatives. The deceased has no concern with that. She will not be a decree holder along with the original plaintiff.
No, I don't understand.
If this type,
Merely because this respondent number 8 is not a co-plaintiff. Does that mean that the proceeding will not abate?
because
Her
the-
rights has crystallized. Simple.
No, because the adjudication, the purpose of suit was for adjudicating the rights as claimed by the original plaintiff. And
Why were these persons made party?
yes, if the plaintiff is seen for the very first page, title suit 47 of 92. That is one Ratan Lal Jain and then one Gulabi Devi. And the defendants includes
Gulabi Devi, number 2.
they were the
Two plaintiffs.
and all other the defendants from 1 to 12, they were all defendants, including Ram Prasad Kewal. And the relief was sought for only in respect of the plaintiffs, not in respect of any of the.
What do you mean? Relief is always in connection
Yeah,
with the property
for the-
when there is a contesting defendant.
For the purpose of abatement, I am making this submission for the
Yes.
purpose of abatement.
Yes.
Because whether the abatement of this appeal against the respondent number 8 would have any impact on the adjudication process or on the status of this
If
settlement.
the right of the respondent number 8 is crystallized, then under
No,
such
because no right is declared so far as the defendants are concerned.
once your right is dismissed, right? The suit was dismissed.
No, the suit was decreed in their favor.
The suit was decreed,
Yes.
right? And the appeal was allowed.
Appeal,
Appeal was also not dismissed.
no, appeal was filed by us. Appeal was allowed affirming finding on the title, but setting aside the finding so far as the title document is concerned. Affirming the finding on title on basis of adverse position, the appeal is concerned. So the
The defendants they claimed adverse possession.
no plaintiff.
Plaintiff claimed adverse
Plaintiff claim. Plaintiff relied on certain title document, a Sada deed, which was considered by the first court, and first court relied upon that deed and decreed the suit. And simultaneously, first court also considered their plea of adverse position and said that if there is no occasion for adverse position, the learned appellate court, upon discussion, finds that the title document is not legal, is not considerable, it does not give any title, but they have perfected their right on basis of adverse position, on basis of that illegal setting. That is the finding of the learned appellate. So the purpose of making this submission is that no right as such of the deceased respondent number 8 or her successor in interest was ever asserted or crystallized in the proceedings. So her death or abatement, so far as abatement of the proceeding against her would not make any difference. Had she been a plaintiff, then things would have been otherwise. Then the question would have arisen whether the decree is severable or it is one and same. That is the submission on the issue of abatement. That it will not make any difference.